You're watching Bloomberg Law. I'm Pacchia. Earlier this week, the United States Supreme Court struck down a Montana state law banning corporate political spending. In what was viewed by many as an opportunity to revisit the court's ruling in the Citizens United case, the majority stood by their prior decision that restrictions on expenditures in electoral campaigns, including those from corporations and unions, violated the First Amendment. Joining me now to discuss is Adam Skaggs, Senior Counsel at the Brennan Center for Justice at NYU School of Law. He's joining us from Washington, D.C. Welcome. Thanks for your time today.
Thanks for having me.
So we have a law from Montana that was 100 years old, and it was basically designed to keep corporate spending out of electoral campaigns. I'm going to take a little bit from the majority's opinion here in this case. Paraphrasing, they said basically that the question presented is basically whether the holding from Citizens United applies to this Montana state law, and they said the answer to that question is there's no serious doubt. Were you surprised by the ruling?
Well, I can't say we were especially surprised, but we were tremendously disappointed. Citizens United was wrong at the time it was decided, and the past 2 years, what we've seen happen with money in politics has just proven beyond any serious doubt that the fundamental idea behind Citizens United was wrong. That idea, the justices said in Citizens United, was that independent political spending could never lead to concerns about corruption. As long as it wasn't a candidate doing the spending, there could be unlimited spending and it could never lead to corruption. And what we've seen over the past 2 years, and going back before Citizens United throughout history, is that just because a group says it's independent of a candidate, groups that pump major amounts of money into our elections can always raise concerns about corruption of the political process.
I mean, this was a rather short statement from the Supreme Court. They did not hear arguments on this case at all. Did you find the discussion about corruption to be a little bit interesting, given it was such a short statement? I mean, it wasn't necessarily something that they had to speak on. What do you make of them making the decision to do so?
Well, again, I mean, you know, the opinion itself is about a page. It's a paragraph, and essentially the 5 justices in the majority sort of brushed off with the back of their hand all the arguments that Montana and a number of outside groups who came in and filed friend of the court briefs had made. Montana passed this anti-corruption law 100 years ago at a time when out-of-state mining interests had essentially taken over the state. They ran its elections, they ran its government, and the people of Montana said, we need to take our government back. We want to take this out of the mining companies' hands and make it a real democracy. And the state of Montana, in defending this law, produced a very large record of facts. They presented a huge factual record that showed Montana's experience clearly confirmed that spending by corporate groups, independent spending, led to corruption. And for the Supreme Court to just ignore the facts, it's as though the Supreme Court said, facts? We don't need any facts. And just ignored it. And that's, again, very disappointing.
This was kind of indicative of the reputation that this particular Supreme Court has garnered over recent years as being rather unpredictable. A lot of commentators and pundits thought that in the months leading up to this decision that perhaps Justice Anthony Kennedy might be willing to revisit his rationale in Citizens United and maybe take a fresh look at this issue. But that just didn't happen here.
Well, it sure didn't. And, you know, I think there were a lot of folks that were predicting, look, it's only been 2 years since Citizens United. The court's not going to change its mind. And so I think, again, those of us who saw what happened were disappointed, if not entirely surprised. But I think that the pundits and the commentators that you just referred to, the folks who suggested surely Justice Kennedy or the other members of the Citizens United Court, surely they'll have a change of heart or at least agree to take a close, careful look at the facts that are presented. You know, they were wrong, but I think it's not crazy to have thought that way because, again, the facts that have occurred, the developments we've seen in money and politics, you just can't seriously argue there are no concerns about corruption that are stemming from this outside spending. And so I think it was natural for some observers to think, surely the court's going to want to take a second look at this. You know, we have a tiny number of individuals, you know, dozens of individuals who are funneling money in tens of millions of dollars, you know, $10 million check to this super PAC, another $10 million check to another super PAC. And when you have a tiny handful of wealthy interests and individuals who are bankrolling millions of dollars, more than the candidates themselves are raising, it raises serious questions. If the candidates that those billionaires and those wealthy companies and interest groups, if the candidates they back with all that millions of dollars win, don't you think they're gonna want something in return for that? Won't they seek favors from the folks that they put in power? So those are the exact corruption concerns that have regulated contribution limits to candidates and other common sense campaign finance regulations. And this court, the Roberts Court, is incredibly hostile and is basically handcuffing government to do anything about attempts, again, by corporations and wealthy individuals to influence government and to capture government decision making.
A lot of people are quite upset, both with the Citizens United decision and now this new decision, but they're also upset about the effect that it's having on our political system. What's next for opponents of these decisions and everything that comes along with them?
Well, there are a lot of folks who are advocating for constitutional amendments to actually go and amend the Constitution to explicitly give government the right to set reasonable limits on campaign expenditures. But that's a long and that's a difficult process. And even without amending the Constitution, there are real reforms that we can adopt today and that we need to get control of our elections back. Most important, we need to provide public financing for congressional elections. We need to adopt a federal law like the one we have in New York City, in which small donations to candidates who are in the public funding system are matched with a multiple match. So in New York City, $175 donated to a candidate is matched with 6 to 1. So $100 a contribution gets $600 of public funds. By creating these systems, it amplifies the voices of small donors and it supercharges the power of small contributions. So candidates can succeed and win election based on getting $100 from a whole lot of candidates instead of going after wealthy fat cat donors and taking thousands, or with the case of the super PACs, tens of millions of dollars from a small number of donors. So we need to adopt a small donor matching program for our federal elections. That'll make the representatives in Congress responsible to the people that they go to Washington to serve, who support them with these small donations, instead of, again, being responsive to fat cat donors. There are some other things we can do as well. We need to get the FEC to start policing federal elections. We need to erect reasonable boundaries between campaigns and the super PACs that right now function as shadow arms of the campaigns. So there's a lot that we can do, and I think after the election, after the smoke clears, a lot of folks are going to look at what happened in the 2012 election and say, we need to do something about this and we need to do it now. So I'm hopeful that we can get some serious reforms passed.
It sounds like you're saying that the focal or the focus in this issue is going to shift now from activity in the judiciary system over to the legislatures around the country. Is this the end of the judiciary's role in this issue?
Well, I think as this Supreme Court makes clear, they're not liable to sit on the outside and watch things happen. The Supreme Court, unfortunately, has chosen campaign finance as an area that it's extremely hostile towards the common sense reforms that states and the federal government have over the past several decades put into place. So I don't think we can expect that the court will take a spectator role in the process. But I do know that even given this court's incredible hostile approach to campaign finance regulations, there are a number of reforms out there, like the ones I just described, a small donor matching program, reasonable limits between campaigns and super PACs, that are fully constitutional, even given this court's view of the First Amendment. And so as long as we pursue those reforms and get those changes passed into law, we'll be on solid constitutional ground, and even this court will let those laws stand.
All right, we'll have to see how it plays out. Adam, I want to thank you for your time today, sir.
Thank you. It's been a pleasure speaking with you.
That's Adam Skaggs from the Brennan Center for Justice at NYU School of Law. If you'd like to learn more about the cases and issues we just discussed, be sure to check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can follow our updates on Twitter and see more of our videos on YouTube. I'm Pacchia. Thanks for watching.